presidential reference. Changes can still reserve it for the president consideration and will not bound by it and advice of council of minister in exercising power under the provision. The bench was answering the reference made by the president Draupadi Murmu in the wake of two judge bench of Supreme Court fixing timeline. Now, President and the Governor in April 8 judgment while decide the matter of to the Tamil Nadu government challenging the state government's act withhold assent to 10 bill. The judge bench had ruled that the bill can reserve for the president holding in first instance. The five judge bench said the text of the first provision to Article 200 its praising shall not withhold assent 3 from clearly indicates that would sought to be curtailed among three options was only option to withhold meaningful withhold return to legislature. The first provision can the first provision cannot be read in a manner so to condition to the option of the governor to reserve the bill for the president's consideration. Therefore, when the bill is returned to the governor, he is still left with two options: either grant his either grant his assent or to refer it to president for his consideration. This power to reserve a bill for the president consideration is respective of whether the bill is returned by the legislature in its amended or unamended form amended or unamended form. On the timeline for the president and the governor to act, the bench said the text of the article 200 and 201 which deal with the president's power with the respect to bills has been framed in such a manner so to provide a sense of elasticity for the constitutional authorities to perform their function, and by consequences the need for balancing that might arise the process of law making in a federal and a democratic country like ours. The imposition of timelines would be strictly contrary to the elastic that constitution so carefully preserved. It said a logical corollary of the reasoning in is that if there are no prescribed timeline under the article 200 and 201, the expiry of them too cannot amount the deemed consent. Earlier, the two judge bench invoking Article 142 powers that had held that the bill which remained pending with the governor for unduly long period of time as deemed to have been assented on the date when they were presented to the governor after being reconsidered by the state legislature. Differing the five judge bench said the concept of deemed assent in the context of Article 200 and 201 supposes that one constitutional authority here in the court could play a substitutional role for another constitutional functionary here in the governor or president. Such a unpatient of the governorial function of the governor, similarly of the president's function, antithetical not only be a spirit of constitutional but also as office specifically the doctrine of separation of power which is a part of the basic structure of the Indian constitution. We have no hesitation in concluding that concept of deemed assent for pending bill by the court is exercise of jurisdiction under Article 142 is truly take over of the role and function of a separate constitutional authority. The reliance on Article 142 cannot lead to supplanting constitutional provision itself. It said that the prescription of reasonable period of time for a quasi-judicial function wherein a speaker act as a tribunal cannot be equated with governation function and governor's exercise of discretion in that regard under Article 200. The bench said portion of April 8 ruling the pertaining to a imposition of timeline on the governor under Article 200 inorious, and it also be pointed that there was no occasion for the issue of setting a timeline for disposal of will refer to president under Article 201 to arise before the court while the considering a state of Tamil Nadu. Thus, it is clarified that any observation on the aspect of timeline applied to the president under Article 201 or conclusion therefore of this aspect are merely arbitrary, out to be treated as such. It said that prescription of timeline, apart from being functional and absolute restraint on the governor and the president, also suffers from the legal affirmities. Firstly, it's prescribed a one size fit all timeline rehearse the nature of the bill and complexity of the issue. Secondly, at the expiry of this one size fit all timeline, it creates a right for judicial redressal, prima facie rendering the act of governor or president support upon the expiry of such timeline. Both these consequences, in our considered view, were uncalled for, as they were neither envisioned when we adopted the constitution nor they are born out of our constitutional practice. The bench also held that the discharge of function by the governor president under the Article 200 and 200 were respectively is thus non-judiciable. The discharge of function by the discharge of function by the governor or president under Article 200 respectively is thus non-judiciable. The two-judge bench had ruled that the president ought to seek the court opinion if the governor had reserved the bill for his or her consideration on the ground of perceived unconstitutional. The five judges which however said the president is not required to seek advice of the court by way of reference under Article 143 on every occasion that a bill is reserved for the consideration by the governor under Article 200. On what we can be done when faced with inaction of the governor under Article 200, the bench said while the merits of an action taken by the governor under Article 200 cannot be looked into by court, in action that is prolonged, unexplained, and indefinitely will certainly invite limited judicial scrutiny. Supreme Court draws red line of the exercise of his discretion. The Supreme Court opinion to the President stated Article 200 outlines the power of a state government concerning bill passed by the state. The striking balance, the Supreme Court effectively defined its role in the front political issue as that of facilitator and dialogue between the state and the center instead of adjudicating as an adversarial constitutional case. The opinion refers to the governor's role in granting assent to the initiation of a dialogic process. The court refers to the process as advisory, persuasive, deliberative, meditative, consultative. By preserving the right of the state to move court against the governor, the Supreme Court opinion underscored that effectively the Supreme Court can only nudge the executive to initiate the process. In the appropriate ruling by the two-judge bench headed by Justice J.B. Pradiwala, Supreme Court in its directive sought to resolve the constitutional impasse when a governor sits on a bill for an indefinite period of time, the negating the elected state government role. The resolution involved a strict timeline and uncertain consequences in case of failure to comply with the timeline. The Supreme Court advisory opinion recognized the same constitutional pressures and its roles in resolving. However, it offers a new prescription, one where it only hold a space for the states and the center to start a dialogue. Yet the court's opinion acknowledged that deliberate inaction can defeat the constitutional scheme. The working of our constitutional scheme is permised on constitutional authorities who are each assigned by a specific but interdependent role, performing their duties akin to cog that keep a clock ticking. They depend on each other to keep the constitutional humming and thus working. They are also constitutionally obligated to offer checks and balances for the other. Such a constitutional scheme thus avers inaction. In other words, our constitutional schemes work only if it worked. However, despite this called inaction by the governor, constitutional courts cannot supplant the wisdom and consideration of the governor and president. The opinion state the opinion underlined that even when the action of the executive constitutionally challenged judicial power under Article 142 cannot be invoked by the Supreme Court to achieve results that are contrary to the Constitution. On the court granting the on the court granting a deemed assent to bill, the Supreme Court opinion state that a takeover and substitution of the executive function by the judiciary contrary to the spirit of the Constitution and the doctrine of the separation of power and impermissible. Which of the following constitutional provision empowers the governors to resolve a bill passed by the state legislative for the consideration of the president? So Article 200. Under which of the following circumstances it is mandatory for the governor to reserve a state bill for the consideration of the president if the bill seeks a curtain the power of state high court curtains the power of state high court regarding the president assent to a bill reserved by governor under Article 201. The president can give assent to bill, can withhold assent from the bill, can direct the government to return the bill, to the state legislature for reconsideration. If a bill reserved by the governor is returned by the president with a message for reconsideration and the state legislature repass the bill, what is the president's subsequent option? The president not bound to give assent even if the bill is repassed. The recent Supreme Court judgment emphasized that the function of the governor under Article 200 are subject to limited judicial scrutiny, partially in case of prolonged, unexplained, and indefinite inaction.